FSB. FSB.
Hello, everyone, and welcome to FSB's very latest webinar, Employment Law Changes, What You Need to Know and How FSB Can Help. I'm FSB's Executive Director, and I have two brilliant guests, and I can't wait to hear what they have to say. And I'm not alone. We have well over 400 registrations for this webinar, which is absolutely mega, and it shows the keen interest in a big package of reforms that hasn't actually happened yet. So I'm going to do a little intro to set the scene. And then we're going to go in depth into the government's Make Work Pay proposals and the legislation with our expert panel. So the first half of this webinar will be to go through the issues, to explain everything. And the latter half is to take your questions. So you'll probably see, hopefully you'll see at the bottom of the screen, a Q&A button. So at the bottom of your Zoom screen. So do click on that. And if you also want to post your views on social media, do at us, FSB_policy or for the advocacy work, or FSB_voice for our member services, including our legal services, or use the hashtag, which was on your screen just now, hashtag #MakeWorkPay. So as you know, probably, FSB has just marked its 50th anniversary as we were founded back in 1974. So that's 50 years as the voice of small business owners in all forms they come in, which is very, very diverse group. So the self-employed and sole traders on one side, limited company directors on another, and small employers. And the primary purpose of FSB has always been to get changes that help these groups. And we do that by lobbying those who make decisions and those competing to be those who make decisions. So people who are in government or people who want to be. And we've got loads of wins, things like changes to business rates, increasing the VAT threshold, and the creation of something called the employment allowance, which we created. We had the idea, and that every year now takes £5,000 off every small employer's national insurance bill. Now, the biggest moments in recent years for FSB have been at spring and autumn budgets, and we're highly focused on the October budget in 2 weeks' time. But at the same time, you have this Make Work Pay agenda coming along on a parallel track. And throughout our lobbying, what we try to do is to get good stuff for our members, but we also want to stop bad things coming that will make things worse for our communities, and often it's inadvertent consequences. So we look to mitigate those, offset them, maybe delay them, or push for some kind of phasing where those with the broadest shoulders, the biggest companies, are focused on first and then eventually move down to smaller firms. So finally, after all that lobbying on good stuff, stopping bad stuff or improving it, we set up direct member services to help our members to face what's coming down the line, using our scale as FSB with our 150,000 members to negotiate brilliant partnerships. So in this kind of way of working, the employment changes we face are a bit like a microcosm of this. So today we're going to go through what's been branded as Make Work Pay. It's barreling towards us at speed. The legislation was published last week, and here it is. I mean, it is absolutely enormous. And if you need some bedtime reading, I would definitely recommend it. 158 pages of legislation, and that's just the first stage. So we've got a couple of great guests to look into what this all means for you as a small business owner. We've got Amelia Quist, who is FSB's Head of Policy Research. And while she looks after, of course, all our research areas, that's policy reports you'll see and the survey programme, she also manages all our policy advisors here in the Westminster office, and she keeps a keen eye on employment issues. Alongside her, we have Hannah Thomas, a brilliant solicitor from Mark L, who is FSB's partner that runs FSB Legal, and she specialises on guidance to small business owners and employers, including FSB's Legal Hub, which is an absolute treasure trove of advice and help and free to FSB members. So we're going to run through what we know right now, as at what today, 16th of October, 2024. And we deliberately scheduled this webinar in so that we could time it just after this bill will be published within Labour government's first 100 days. We're going to go through each major element as they face small businesses, and also what didn't make the bill but still has an impact. We're going to look at what the timeline will be, what will hit you and when, and also what we expect to come in phase 2. As an FSB member, you'll also get a feel for what help having FSB Legal in your corner will be. It'll be absolutely crucial. And we've had a summer I would say, of unsourced and probably unreliable scare stories in the media about what might be in this package. So right now, let's cut through it. So let's dive in. Let's start right at the very start. We've got this bill. It's got 150 pages in it, 28 different policy proposals. That's a lot for a small business owner to take in. So Hannah, shall I go to you first? Can you kick us off first with your overall impression of the package?
Absolutely. No, thank you for the introduction. Now, the government has hailed this as the biggest upgrade of workers' rights in a generation, and that is not hyperbole. It really is a juggernaut of a bill, I would say. The bill is huge in scope, and it covers employment areas from day one unfair dismissal rights, significant restrictions on the use of zero-hour contracts, changes to flexible working, enhancements to parental leave and maternity protection, bereavement leave for all employees, not just for bereaved parents, statutory sick pay changes, and a duty to prevent harassment by third parties in the workplace, and a very significant restriction on the use of fire and rehire. Now, we have published our own briefing on the Employment Rights Bill and on the next steps government proposals. And you can find this briefing on the FSB Legal and Business Hub. So this is our summary and our analysis of the bill from the point of view of small businesses. So do have a look there. And of course, we will keep you updated. We are here to help guide members through these changes as they take place.
Brilliant. Thank you for that. And I know the 24/7 legal advice helpline that you operate for us takes many employment queries, and it sounds like that's only going to increase. So, Amelia, let's go to you next. Can you talk us through FSB's policy position on the package until this point? What did we do talking to Labour in opposition and now in government?
Thank you, Craig. Yeah, so FSB has had a long-standing communication with the Labour Party before they came into government in July and since. And so we were aware earlier this year of some of these proposals or some of the ideas the Labour Party had in regards to employment. And as many people on the call will know, that small businesses as employers provide good employment, but they often struggle to kind of deal with the legalities of many of the complexities of the law. They don't have a HR department sitting up on the 10th floor. The business owner is obviously the employer, but they're also the person kind of working out all of the HR issues. So we've presented that to the Labour Party and had loads of discussions with them, highlighting some of the difficulties that some members may face. We've argued for the rules, as I say, to be proportionate, as you talked about. Some of the things that we've been successful on have been on the unfair dismissal and ensuring that there's proportionate time for that probationary period, and also on zero-hour contracts. We've presented our research to Labour and highlighted some of the issues in terms of the complexity and the use of zero-hour contracts within our membership. So we've had really positive discussions, both at a ministerial level and at a roundtable level. Colleagues and I have attended meetings with DBT to speak to them about a number of the issues.
Great, thank you very much. That's a lot. And it has been a real dominating feature, I think, in all of our kind of lobbying more broadly as well. The government has a huge majority. So we're not going to see running battles in Parliament like we all remember with the government with little or no majority over Brexit, but we do have some influence. So let's get into the meat of this. So each key part of the package in more depth. So I'd like to take first what's become known in shorthand as day one rights. And the first one really of those is, and we've been very vocal on this at FSB, is the right to claim unfair dismissal. So Amelia, first here, why is this such a big deal to change from the current rules where an employee has access to a tribunal after 2 years in the job?
It's a big deal. It's probably one of the biggest issues within the employment bill. Many people on the call will know that unfair dismissal has been in place in terms of the 2-year qualifying period since 2012. So this current law has been around for some time. Essentially, what Labour are proposing is that individuals will have a day one right to unfair dismissal, which obviously removes the 2-year qualifying period. It proposes a number of questions for employers. What does that mean about probationary periods? What rights will they have in terms of dealing with staff that may be performing poorly? Essentially, there's a number of legal questions which Hannah and the team will provide answers to, and our employment law service will also provide support to.
Okay, so the 2 years is effectively goes, and there's this new sort of light touch procedure during a new type of probationary period for 9 months. So Hannah, can you explain, what do you think a small employer should do differently in anticipation of this change? You know, do they need to prepare now? And then what do you think they will do to cope with it when issues happen? What is a light touch dismissal procedure within 9 months?
Yeah, as Amelia says, this is a huge change, and this is the most significant proposal, and it's the proposal that we're seeing cause the advice line around now in terms of the proposals, albeit that it's not scheduled to take place before autumn 2026. It is a huge one. What I would say to small business employers now is that you don't need to take any action as a result of this bill. So you don't need to do anything now. Don't panic. Absolutely don't do that. We'll be ready with legal updates and changes to our relevant template documents on the hub once these new laws come into place. However, what I would say is once this change takes place, perhaps in 2 years' time, is that employers are going to need to be a lot more careful in how they handle dismissals for relatively new employees. Currently, new employees do have certain rights to bring an automatically unfair dismissal claim. They do have rights to bring a claim if they believe the dismissal is discriminatory based on a protected characteristic. So it is not risk-free if you are dismissing a relatively recent recruit. And I have to emphasise that because we do advise from a risk management perspective on the advice line. So really important for small business employers to bear that in mind. But what is really significant about this for me is that the government has proposed a light touch dismissal process. We don't know what that's going to look like yet, of course, because we would have to wait for the consultation and regulations. This light touch dismissal procedure would apply during the initial period of employment. We don't know what that initial period will be yet because the bill doesn't say, but the government has proposed 9 months. So what I would say about this to employers is that it's not just about the procedure, because it's not a tick box exercise. The employer still needs to ensure that the process is fair overall. So it's going to be looking at that huge body of case law that we have. So basically previous decisions of the employment tribunals and courts since the 1970s around what a fair dismissal process looks like. So I think it will be more important to take legal advice where you are dismissing short-serving employees, as employers would usually do for longer-serving employees. I think that's the key point for me. It's a really fundamental change, I would say.
Great, thank you. I mean, listening to those 2 points, I mean, we've picked up that that problem of risk. Small businesses want to employ people, they really do, and they want to, everything. Obviously, everything should be fantastic and every employee fits, but sometimes you make a mistake in recruitment. And so we know that small businesses are worried about getting sued. We know what they're worried about making a mistake, and they just need some protection in how to do that. And I reckon that the autumn 26 date, I think that may well fall backwards because in the legislation it says no sooner than autumn 2026. So even if they do it as fast as possible, this is still the last thing they'll even turn to, and it could even delay more. So I love the advice about don't take action now. And the second thing is I think there's a confusion in the community about 2 different probationary periods. So there's probationary periods you have now in your contracts of employment, but this new light touch period is being called by some people in government as a different type of probationary period. That's really confusing. So hopefully that will be tidied up, I think, before it becomes into force. So Amelia, do you mind running through the other day one rights changes that we saw announced? And, have these been more proportionate and reasonable? And does FSB welcome those?
Thank you, Craig. So there's been a number of discussions about changes in regards to day one rights, and it's quite important to lay out what's actually in the bill and what's not in the bill. So in terms of day one right changes that we've talked about unfair dismissal, there's also a change in regards to paternity and parental leave. So these will now be a day one right. And FSB is very supportive in terms of providing more family benefits in terms of leave to individuals. There's also another change in regards to bereavement leave. So at the moment, we have something called parental bereavement leave, and the government is planning to expand that to bereavement leave for everybody, not just parents. Previously, FSB has supported parental bereavement leave for staff, and we will be working with the government to understand how the legislation will work in practice. one of the key things for members on the call is a small employers relief. So small employers relief is a scheme which allows small businesses to claim back some of the money in regards to statutory paternity types of leave, so statutory payments. And so if any of our members aren't aware of this, please do contact the Employment Advice Line. They'll be happy to kind of talk you through those changes.
Great, thank you. And Hannah, do you have anything to add on these? Have you had many calls to the advice line from FSB members on these sorts of areas?
We have had quite a few calls to the FSB advice, and I think the issue is the reporting in the media sometimes has been rather hyperbolic. There has been some, dare I say it, clickbait headlines. So I think there has been a lot of confusion among members that we've seen among members about what is law now. Has anything changed now, or is anything going to change imminently? So I think it's important to have that access to reliable legal advice on the advice line for members and also on the hub in terms of what is law and what we can expect. And we've also had quite a few calls from members who are particularly concerned about the day one unfair dismissal rights for employees, because currently they are very comfortable with the 2-year rule for unfair dismissal rights, and they feel more relaxed about that when they are hiring staff, because they have got that long 2-year period in terms of not being overly concerned about unfair dismissal rights. We have had, as I mentioned, we've had other calls from members who are just unclear. For example, in the area of 0-hour contracts, do they need to do anything now? What's changing? Can I still employ people on these types of contracts? I think that's pretty much the flavour of the types of calls we've been getting from members on our employment advice line.
Great, thank you. So that's day one rights. And do keep asking your questions in the Q&A. What I'm going to do, and we're going to look at all the questions we've got in, and I'll choose the ones that have kind of got the most popular, that's probably the wrong word, the most commonly asked areas. We'll look at those. So next we'll turn to 0-hours contracts as the government pledges to stop exploitative ones. I'm not sure we've got any closer to a definition on that. So Hannah, what are the specific proposals as you see them? And what's this new reference period all about?
Yeah, I mean, I have to be fair. There are some complicated provisions that have got employment lawyers scratching their heads over the weekend and over the previous days. So I have to say it's convoluted. I think that's the nature of the beast when it comes to different working conditions, types of working patterns for people on 0-hour contracts. And also because the government is really keen to draft in anti-avoidance provisions so that employers can't find a way around this legislation. And I think that's why it's so complex. But in terms of the proposals, it does mean effectively that employers won't be able to use 0-hour contracts or contracts with a very low number of guaranteed hours unless the workers agree to working under this type of contract. So it's really significant for those sectors or those businesses that do use or are reliant on 0-hour contracts, or they perhaps guarantee only a low minimum number of hours. So it's a really significant change for those types of businesses. And what it does, or what the bill proposes to do, is give those workers a right to guaranteed hours based on their average hours that they work over a reference period. And this is unless they choose to remain on this type of contract. The government has previously proposed a 12-week reference period. I mean, the reference period will be set out in regulations later on, but they've previously proposed a 12-week reference period working out those average hours. Significantly, for me, from an administrative point of view, it does say that the employer will then need to make an offer of guaranteed hours, and they will need to repeat that offer after each reference period. So administratively, businesses are going to need to bear this in mind in terms of not falling foul of that legislation. And the bill also gives the right to reasonable notice of shifts. So again, another administrative burden for businesses that use these type of contracts. And it will also give workers a right to a proportionate amount of compensation if those shifts are then cancelled or they are changed or they are shortened. So I think there is a lot to manage and think about if those businesses are going to continue using those types of contracts.
Great, thank you. And then Amelia, I mean, 0-hours contracts has been on our radar of lobbying for some time. But I guess it hasn't been a kind of top flight focus. Many small businesses say they don't use them, but they have grown in our survey data, I think. And what does that tell you? What does that tell us about the use in kind of our part of the economy?
Thank you, Greg. Yes, so we know from our own research that there is some use of zero-hour contracts among smaller businesses. This tends to be kind of vary across different sectors. So within the hospitality sector, for example, they're more likely to use zero-hour contracts. And as Hannah mentioned, zero-hour legislation can be quite complex depending on the working arrangements between the individual and the engager, and also the various pay arrangements. So we've seen some of this complexity within our own research, and we're hoping to kind of do some further investigations. So for anyone who's on the call, who's an FSB member, do look out for our surveys that come to your emails. And if you have signed up to this event, you'll also receive emails about our surveys, because it's really important for us to collect the most broadest and richest data to inform the government, and particularly on 0 hours, because it's quite a complex change that's coming in.
Thank you. I mean, this is a big one for 2025 then. So let's turn next to sick pay changes. And it's one of two big increases, I guess, on the pay front, alongside quite a high profile increase to living wage to include a cost of living element. But with sick pay, there's a move to expand sick pay to the first day, or to upgrade it to the first day. And the meetings I've been in with big business groups, often corporates, government, public sector, big trade unions, of course, for all of these, they pay 100% of salary on day one of sickness. But salary sick pay is different for our part of the economy. So, I mean, Amelia, can you set out what SSP is, what the changes will mean, and also perhaps touch on what will happen, you think, to the living wage next year?
Yes, so statutory sick pay, the government is planning to make some changes to statutory sick pay, as you've mentioned. One of those is making it a day one right, so individuals won't have to wait for days. There's also another change in terms of removing the lower earnings limit. Now, for employers on the call, they'll be wondering, what essentially does this mean? There'll be a larger number of individuals, employees, that will be entitled to statutory sick pay going forward. From an employer perspective, it's also likely to increase their sickness absent costs. So just dealing with SSP from a cost perspective. So we know from our previous research that on average, for over a 12-month period, a small business is probably spending over £3,000 a year on SSP. So it can be quite challenging from a cost perspective, especially if you have a very small team, and if someone is off sick for a long period of time, you're having to cover that sickness absence cost in terms of SSP, and also providing cover for their work. So over the last few years, FSB has been lobbying quite hard, engaging with government on SSP. The previous government were looking at statutory sick pay and making changes to it, and we were successful at introducing the rebate into that consultation. Now, that was before the pandemic, and so obviously we've also had a change in government. So we've been engaging again, as we said, with Labour to highlight the need for the SSP rebate. We did see during the pandemic that FSB was successful at lobbying and introducing the COVID SSP rebate for small firms. That was one of the first COVID measures that was introduced. So again, SSP, as we know, it's a big issue for our members. Many members will be querying now what they need to do as the legislation comes forward, as these changes come forward, but why it's really important for members to be speaking to the employment helpline.
Great, thank you. I do remember some of the big meetings we had during Omicron in particular, that COVID variant towards the end, where we did get it back in. It was so vital. So, I mean, Hannah, what can small businesses do to help mitigate the situation as they face these extra costs on sick pay? Do you get calls already on this?
Yeah, this is one of the largest category of calls that we receive to Legal Advice Line. It's around issues of managing sick leave, managing the cost of statutory sick pay. I mean, of course, if a worker is eligible for statutory sick pay, then the small business must of course make that payment. But there are certain things that the employer can do to mitigate the amount of sick leave potentially that employees might take, and that's going to be actively managing those patterns of absence. For example, calling in employees to return to work meeting, finding out if there are any underlying causes of the need for the leave. If, for example, there's evidence perhaps that the employee is malingering, so the need for the absence isn't genuine, then of course the employer can choose to manage this under their disciplinary procedure if it's appropriate and fair to do so. If the employee just needs a little bit of extra support, then the business can look at reasonable adjustments, things like phased return to work, perhaps even temporarily adjusting their hours, if the business can support it, i.e. if it's reasonable to do so. So there are some steps that the employer can take. We do appreciate the fact that small businesses are much more impacted by employees taking leave, and particularly as we've seen in recent years where we have more perhaps more mental health sickness, where that could be variable. It can be unexpected when an employee might need to take that time off. And this is the sort of thing that obviously small businesses are really keen to support their staff, but this is the sort of thing where we see small businesses do tend to struggle.
Great, thank you. I mean, these things, so we've gone unfair dismissal, day one rights, sick pay, 0 hours contracts. These are all really big, chunky policy changes on their own. Just one of those. Doing all those 4 and then looking at the other 28 measures of the 28 measures is really big. So, I mean, other areas such as trade union organisation, fire and rehire aren't, I think, particularly areas of concern at the moment for us. But there are sort of some areas in between these 4 big ones, things that aren't hugely relevant. There's some areas in between where we've had some changes flagged that sound big, but could be, hopefully, more manageable. So let's cover those. And the first one I think we'll turn to is flexible working. We've had one question this on already. So at the moment, there is a right for an employee to request it. And our issue really is that the government may come in and make it more overly formalised, using an approach that works well for a big corporate with an HR department who is trying to equitably manage the application of a policy across thousands of employees, while the small business already provides a lot of flexibility, but they do it flexibly, informally. So we're a bit worried about this initial formalisation now being a potential default. So, I mean, Hannah, can you take this one? Flexible working wise, does that feature also in the calls? And what do you think the changes will mean?
Yeah, I mean, I think in terms of how it was initially proposed, it did give the impression that this would become a day one right, so the default for employees. But the legislation is narrower in scope, so it won't be so impactful. So what it means is that the employer will need to be a bit more careful in terms of the justification if they are seen to be dealing with a request reasonably. So they can still reject the request for one or more of the existing 8 statutory reasons, but they will have to demonstrate that they are reasonable in selecting that reason for rejecting the request. So they will need to show how that reason actually applies in the situation. They will need to give a bit more thought. So there are so administratively, there will be some increase burden, for want of a better word, on the small business employer. But we find on the advice line that small businesses are very good at managing these requests informally. They don't tend to go down the formal statutory procedure for managing flexible working requests. This tends to be done informally. So I'm just looking at one attendee's question. They are a retail business who use casual contracts. Also, obviously, we have a request, or was it a question around, does this mean that we can't refuse requests to work from home? We can't have a policy in place that says, you have to work in a certain way. It doesn't mean that, because employers, as I mentioned before, they will still be able to reject the request for one or more of the specified reasons set out in legislation. That's not going to change, but it just means that employers are going to need to give a little bit more thought to it when they are rejecting those requests in terms of justification and being reasonable.
Thank you. Okay, and we'll do the questions if it's okay. We'll do the questions afterwards because we want to kind of come back and see which members are really, really interested. I would say, there's been some chatter about a code of conduct. Did you spot that in the legislation, that people will sign some kind of code of conduct to say we really embrace flexible working and here's what we think it is?
Yeah, I imagine that's going to be on a voluntary basis. And I mean, it could be that for employers that this could encourage hiring, so this could make the role more attractive. I have seen already in advertisements that the employer makes it very clear whether the role can be done flexibly or not. Of course, I doubt very much there's going to be any statutory obligation on the employer to sign up to a particular code of conduct. we do bear in mind that we do already have a statutory code, an ACAS statutory code of conduct, which sets out the considerations that employers should follow for dealing with flexible working requests in order to ensure that those requests are dealt with reasonably, because there is compensation that could be payable to the employee if a tribunal finds that the employer hasn't dealt with a request reasonably, albeit we don't see an awful lot of litigation. The biggest risk is, of course, if someone claims that the refusal is indirectly discriminatory, for example, because the employee is disabled. So that tends to be the biggest risk. So I don't really see this as a huge change for small business employers.
Great. And Amelia, what evidence have you seen in kind of FSB's survey data about flexibility? And is there a risk about this formalisation that you see there too?
Well, as Hannah's mentioned, informal flexible working in terms of giving that to staff is quite popular amongst smaller employers. They tend to go through that informal process rather than the formal process, largely because of the small nature of their teams, the kind of the family kind of workplace that they have. So our research has shown that 89% of small employers provide some form of flexible working to their staff. And it's really important to clarify and say flexible working doesn't mean just working from home. There are other types of flexible working on offer, such as reduced hours, compressed hours, etc. And this is why it's really important to kind of highlight that to individuals. As Hannah's kind of laid out some of the changes that are there, as we've seen in the news, lots of headlines about flexible working over the last few weeks. The bill doesn't mention anything about a 4-day working week, for example. And as I said earlier, we'll be going out to members and kind of collecting more research to understand how these changes may impact them and their businesses.
Great, thank you. Another area in all of this is about, we're talking about employers a lot, but there's also the Taylor reforms coming. And there was some debate about would the government, get rid of the boundaries or change them between someone who's employed, someone who's self-employed, and someone who's got this kind of middle status of a worker. That would have a huge structural change to the self-employed, the 4 million self-employed in the country. So, you've done a lot of work with Taylor. What do you think will now happen? And will that have an impact?
So the bill doesn't mention anything about self-employment status. However, the next steps document does. And we know that Labour have committed to abolishing the 3-tier approach, which you laid out, Craig. And so we're quite keen to be involved in those conversations because, as you said, they will directly impact the self-employed, and the labour market more broadly. And it's quite complex. So when Matthew Taylor looked at this issue a few years ago, there was a huge consultation. Many people fed in and kind of provided views to the government. And we highlighted and expressed that we need to keep and maintain that flexibility within the labour market. Any significant changes to the law can shift things quite dramatically. As we've seen, as the labour market has rebounded in some places since the the pandemic, maintaining flexibility is really important if we want to see people working within the labour market and reduce inactivity as well.
Great, thank you. And this is a final call for the Q&A. We're going to do 2 more small things before we open up. So one of them is about Northern Ireland and why it's different. So this bill is a GB bill for Great Britain. So that's England, Scotland and Wales. But there is a parallel process in Northern Ireland where our colleagues have been lobbying really intensely on their own bill, and they've just finished a consultation on it. So Amelia, can you set out for us what the changes are likely to be there in Northern Ireland?
So yes, as you mentioned, our colleagues in NI have been working quite closely with officials. And so similar to some of the issues that we've been talking about, Northern Ireland is presenting a number of clauses to kind of be introduced within their legislation. So this will be introducing some policies that already exist here within the rest of the UK. So for example, holiday pay in the reference period. At the moment in Northern Ireland, it's still 12 weeks. And the plan is to bring that, align it with 52 weeks. Some of the changes that were introduced in the last few years in terms of neonatal pay and leave. So many of our members in Northern Ireland have been wondering what all of these changes are and what they mean for them. So do kind of look out for any emails and kind of correspondence that comes through, so you're up to date and know what to do.
Great, thank you. And Hannah, do you, as FSB Legal, you provide the support service for Northern Ireland just as you do in the rest of the country, don't you?
Yeah, that's right. I mean, we provide exactly, FSB Legal provides exactly the same support service, access to the hub for members in Northern Ireland as in the rest of the UK. It can appear complex in terms of employment legislation, what particular legislation applies to a particular contract, but us or the advisors, they will know which legislation is relevant and we'll be able to advise accordingly.
Fantastic, thank you. And I'm really grateful for working with our colleagues in FSB and Northern Ireland on it as well. So Emilia and I, just so everyone knows, Emilia and I will cover UK wide, and we also do England, and then occasionally we do like this GB. So I mean, can we talk about something else? The right to disconnect. This was one of those quite silly August silly season media kind of stories. Now it was kind of broadcast there would be this, that the employee would have, would not be able to be contacted outside of some core hours. So this doesn't seem to be in the bill. I mean, and Hannah, do you think that means it's over? Has the right to disconnect been disconnected?
Yeah, I think indeed silly season. I was asking, are we all going to be working 4-day weeks, for example? I don't think that will be the end of it because the government is still committed to introducing some sort of measure around the right to disconnect. It's really essentially to address this blurring of boundaries between, particularly with home working, between work and home. I know I'm guilty of that sometimes myself, but I doubt we're going to see it in legislation. It may just take the form of a code of practice. I don't know yet whether that would be a voluntary code of practice or whether that's going to be a statutory code of practice. I mean, if it's the latter, then it could be the case that in any relevant tribunal claim, there could be an uplift to any compensation if the employer hasn't followed that statutory code of practice in terms of contacting outside agreed hours of work. So that's just something to look out for. But I think certainly it's not in the bill, and it would be something that we would see consultation around at a much later stage.
Great, thank you. And then one I've picked up is about this impact assessment. So normally, with a bill like this, that's been a manifesto commitment and been rushed for 100 days, you'd expect an impact assessment to be published by something called the Regulatory Policy Committee in government. But it hasn't been published by the bill, and we are talking to government right now. We think this could be partly because of the unseemly rush to get this bill out of the door within 100 days, which was the commitment. I think the 100-day thing in policy, it can be slightly, I don't know, fetishized, can be quite a good comms device, but it's not brilliant for policy making and making good policy. And we think it's really important the government's clear on what the impact will be, what the costs will be, and where they'll fall. And we have a suspicion that they will fall primarily on small employers. And so for a transparency process, we want that out. Now, the government will be going to its second reading of the bill early next week. We think Monday, potentially Tuesday, but let's see. So really, we're talking to the government about where is this impact assessment? Why is it not being published? And when will it be if it's not been done yet? So let's go to the Q&A. What we're going to do, because we've had, I think we've had 12 questions put in already. I'm going to try and group these based on the kind of the topics. Let's do the unfair dismissal first. And the first question on that was, how will this change affect the contract of employment? Would it be effectively a 9-month initial employment period and then a confirmation of permanent employment? Probably, Hannah, that's one for you.
Yeah, I think that's one for me. That's a good question. The simple answer is we don't know. We don't know. I saw a reference to this, there being a statutory probationary period, which I think could introduce a level of complexity, because at the moment probationary periods are simply a contractual, so they're just an agreement between the employer and employee. They don't have any legal significance beyond that. So I really don't know if that means that the employer can only take advantage of this light touch procedure if they have a probationary period clearly set out in the contract and they follow the letter of the contract in terms of managing that probationary period, because that would be an additional administrative burden for the employer, could create additional risks. So I don't know is the short answer, and watch this space, essentially.
That's fine. And then a couple others I'm going to pick up. One is how this affects seasonal workers, because they like to take people on and won't know if that's worked until a week or two. And then an HR consultant has asked about the volume of tribunal claims likely to rise from day one, and could we lobby for the introduction of registration fees? Now, for tribunals, from my knowledge, there's a huge backup of tribunals, even now based on a 2-year period where you can't do it unless certain terms that Hannah referenced before, which are quite narrow. So if there's 500,000 cases backlog, if it takes 2 years at the moment, so you wait after 2 years, there's a claim. 2 years after that is when the claim will actually probably be heard by the tribunal. So one of the reasons why there's such a backlog is the lack of fees. And of course, suddenly this change could open up to even more. So, I mean, Amelia, can I just ask you what your view is on that?
Yeah, I should say
And
that
sorry, on
was
seasonal
great.
workers as well. Sorry.
And okay, I'll go for the ET claims issue first. So yes, as we know, a number of these changes are likely to see an increase in number of people making claims to the tribunal. And this is quite a complex and scary situation for many employers. Often enough, they don't understand kind of the legalities of the legislation that's presented to them. As you've also mentioned, there's a huge backlog that's going on at the moment. This increased during the pandemic. I think the government really needs to look at what support is there for people bringing claims from an employee's perspective. FSB has done a lot of work previously when employment tribunal fees were in place. And I think there's a discussion that needs to be had with government in terms of the support that is provided to small employers, especially going forward.
And then on seasonal workers?
So on seasonal workers, I'm just looking for the question just to remind myself.
That's right. It's basically how this affects seasonal workers. We run a marquee company, so most of our staff are on a seasonal contract. We take on new staff that may not be suitable, but don't know this until they've worked for a week or two.
So that's an interesting question. I think it will depend on the contract the individuals are working under and whether they're a worker or an employee. It would also depend on the working arrangements that they have and the pay arrangements that they have. So whether those workers maybe are on a 0-hour contract might be a factor, whether they're in a low working hour contract. Those changes to the 0-hour regulations may apply to them, but also the day one rights issue may apply to them. So I think for that individual, for that member, if they're able to contact the employment helpline, it's going to present some of their facts and provide more specific advice.
Great, thank you. And then Hannah, there's a couple here on the broader day rights thing. So one is what will happen to trainee or fixed term contracts in terms of day one rights? And the second is, are there any changes to agency working rights that would about coming into effect from day one?
Yeah, I mean, in terms of being on a fixed term contract, a temporary contract, the bill is clear that it's going to apply to all employees. And as Amelia summarised, it really depends on employment status, who's going to benefit from this right. So if they are an employee, then they're going to benefit from day one, regardless of the type of contract they're on, whether it's short term or 0 hours. If they are a worker, then there's no proposals to give workers those employment unfair dismissal employment rights. But bear in mind, we have got much later down the line, we have got this consultation around removing that intermediary worker status. So, well, there is obviously a much greater risk much further down the line there. Yeah.
Thank you. We've got quite a few on 0 hours contracts. So should we take a couple of these? So we take to the first two. We are a retail business. We use casual contracts during holiday periods for university students, etc. Is legislation more specifically targeting 0 hours contracts that require exclusivity, or will it cover more flexible contracts that suit both parties? Hannah, do you want to take that one?
Yeah, the bill doesn't make that distinction. The bill does cover 0 hour contract generally. So I don't think there's going to be, we already have legislation around banning the use of exclusivity clause, or at least they're not enforceable in relation to 0 hour contract. They already came into place in 2015, so we already have that legislation in place. Obviously, we'd have to see what the regulations look like in terms of fleshing out that definition of qualifying 0 hour contracts or qualifying low hour contracts to see how this works. But I had noticed that it's really strong on anti-avoidance provisions. That's the level of complexity of those arrangements in the bill to really make it clear that the employer can't avoid those provisions by simply granting someone very minimum fixed out guaranteed hours, rather to bring them outside the scope of that legislation. So it will be very tricky for employers that have fluctuating demands or need to change shifts at short notice because something has changed in terms of their sort of client demand or work or something like that. So yeah, these are really wide-ranging proposals.
Thank you. And I think one of your points you made before is about the timeline. So, you know, the primary legislation, this big, huge document is here, but as you can tell from our comments, it is quite unclear what will happen next. And that's because the next stage of this will be secondary legislation, and we're expecting lots of consultations. Really thorough consultation is what we're pushing for on each of those things, which will take place over the next, well, it's not going to be this year. And there's arguments about when in 2025 we might see those consultations start. It could well be they could start in spring next year. And of course, that takes weeks, that takes 12 weeks of consultation. And then you have the legislation put through. So this is going to be some time. I mean, even the primary legislation won't be through the House of Commons until we think next autumn. So this is all, delay is actually really important because that means they can take the time to get this right. And that's what we're talking to government a lot about. So I think that answers the timeline date for end to 0 hours contracts. That, you know, the answer to that is we don't know, but you shouldn't expect anything before 2025. And then certainly more later in 2025. Sorry, there was a question from Michaela as well, which I didn't take. Sorry, it's just disappeared on the screen. If we use 0 hour contract and each assignment is treated as its own agreement, will the 12-week period affect this use of contract this way? Hannah, do you get that one? Maybe.
I think that's a really good question, because I really suspect that in regulations there will be anti-avoidance provisions which will avoid an employer using continuous short-term contracts to avoid the effects of the regulations. We'll have to wait and see and watch this space in terms of those provisions, but I strongly suspect that will be factored in and fleshed out in regulations in future.
Great, thank you. And then Amelia, this one about the reference period by Alex, asking, read a reference period for offering a fixed hour contract. Is there a cap on hours in the reference period? Can you see that question?
Yes. So we don't know specifically if there is a cap on hours in the reference period. As many people on the call might know, in regards to employment law, the reference period when we're looking at holiday pay can be quite complicated. And I imagine the reference period for 0 hour contracts is also going to be quite complicated in terms of what falls under that. We've had discussions with DBT in terms of looking at those individuals when earning the national minimum wage, how national minimum wage regulations need to change if 0 hour contract legislation is also going to need to change. So there's many complexities here. As you've mentioned, Craig, there's going to be a whole host of consultations, and it's really important that we kind of present and find out all of these different types of examples so we can present them to government so they find the solutions.
Great, thank you very much. There's got a question here about sick pay. Sick payable from day one will be wide open to abuse by employees, every hangover, every time someone just fancies a duvet day. So how can a small business cope with this? I mean, Hannah, could I ask, you know, if you get called by a small business saying my employee has a hangover and fancies a duvet day, what can I do? What would the answer be?
Yeah, this is already a really common question we get, because don't forget, it's not just about paying the sick pay. It's also about the knock-on effects to the business and other staff. They've got to pick up the slack, haven't they? Sometimes a small business owner rolls up their sleeve and has to sort of take over some of that work. It can be very disruptive, and it all comes back down to mitigating that risk in terms of investigating it. So if you note an obvious pattern, they hate Mondays, for example, or following a match on a Sunday, then on a Monday they're going to call in sick. It's about looking out for those patterns, making sure that they self-declare their absence, give the reason, following up with the employee. And obviously you've got to get that balance in terms of acting reasonably as well, though. But it is about taking those steps. And of course, picking up the phone to the advice line. If you've got a troublesome pattern here or a troublesome employee, it is about picking up the advice, and that's what we're there for. So.
Thank you very much. So there's a question online which we've dealt with already, if that's fine. There's a question about, for you, Amelia, I think, the minimum wage calculation changes, which I think is referring to the living wage, cost of living component, and probably the age band change as well. Can you just run through, will there be a significant rise? And I presume that's April 2025, right?
Yes, so the national living wage and the national minimum wage increases largely every April. So obviously this year we've seen a change, and we expect to see a change in April of 2025. The government has set out a new remit to the Low Pay Commission. So the Low Pay Commission is an independent body which advises the government on the national minimum wage. The government has also said they plan to remove some of the age bands. So at the moment, the national living wage kicks in for those who are 21 and over. And the government is proposing to remove 18 to 20. So we presented our evidence that we collected earlier this year to both the LPC and to government, and essentially showing removing that 18 to 20 band will have quite a big impact on those employers working in hospitality and retail, and more likely because they're more likely to employ younger individuals. So there will be some changes in terms of calculation. We expect possibly coming from April of next year, but we hope that will be a phased approach and be gradually introduced in terms of those changes.
Great, thank you. And we've had quite a few people ask, sorry, what is the difference between a worker and an employee about these Taylor reforms? Do you mind just clarifying that for us?
I might hand over to Hannah to give.
Okay, yeah, that's fine.
Fair play, Amelia, absolutely. Yeah, it's rather complicated because there isn't a statutory, well, there is a statutory definition, but that statutory definition is basically clarified, for want of a better word, through case law. It's really, really complex, but generally speaking, within an employment relationship, we see this mutuality of obligation between the employer and the employee. If someone is a worker, then generally speaking, there's no right, they have to provide personal service, so there's no right of substitution. But the tribunals, it can be incredibly complicated and fact specific because the tribunal will have to look at the evidence. It's not just what's written in the contract. We've seen this through case law such as Uber. It's not just what's written in the contract, but it's the reality of the relationship. So they'll look at the facts, apply the facts to the law, etc., etc. So it's incredibly complex. And I suspect that this proposal, this consultation will be a long one. It's a complicated one. If we look back to 2018 and the Taylor Review, this is something that past governments have tried to address. I suspect they've abandoned it because of the sheer complexity of it. But you know, it's a long-term, longer-term consultation and proposal. I think the most significant change is whether that will conflate the considerations for tax purposes and employment law purposes, because that would be a very significant change. But I think we'll have to watch the space.
Great. We've got a couple of specific ones. So we've got a few minutes left, so we've just got enough time. But we've got someone who provides musical instrument lessons. Currently, if the teacher is sick, we rearrange the lesson. The teacher gets paid when the rearranged lesson takes place. It seems to me I'll have to pay them for both the cancelled and the rearranged lesson, even though you only receive payment from the customer once. If so, I can't see how to afford it. So obviously today isn't about giving the direct advice, but taking that as a hypothetical, what's your instinct on that one, Hannah?
Yeah, I think my instinct, it won't be a windfall for the worker. My instinct is that any compensation for short notice cancellation means that the compensation is going to be fixed, it's going to be capped, and it's going to reflect their financial loss. So how much are they out of pocket as a result of that cancellation? So I very much doubt that wouldn't be reasonable if the employer has to double compensate. But I see the point that you're compensating the customer, the client, I see that, and that you're also having to make a payment to the worker. So yes, you're absolutely right. There will be that additional cost, unfortunately.
And then the other speak one of you is from a healthcare training recruiting agency where we provide training and healthcare staff to private healthcare. How would this affect us in terms of the nature of our business? We predominantly issue 0 hours contracts for prospects and consultants. Also, Hannah, I'm afraid.
Yeah. I mean, I think in terms of my summary of the proposals in the bill, yes, it's a big change. It is a big change, but we're going we're going to have to wait and see what is set out in regulations, how that's fleshed out.
Cool. Jonathan asked, didn't hear an answer to the agency staff question. So sorry, that's probably my fault. Which was what is the impact on agency working rights? I don't know if either of you would like to take that one.
Yeah, actually, I should have very briefly answered. I did see that question pop up. It's a very relevant one. In terms of the changes to 0 hour contracts, there's no proposal in the bill that they will affect agency workers, but the government has reserved the right to include agency workers later on. We'll have to wait and see in terms of the consultation and regulations on that one.
Great, thank you. There is all, I mean, most of those we have now answered. There's one standout, which is the last one probably. Will 0 hours legislation also apply to young employees, i.e. part-time jobs? To which I guess I know the answer. But I mean, Hannah, do you want to just take that? Maybe with one word answer.
Yes.
Yes, exactly. Right, that's key. So I think we have 5 minutes left. There's something about sexual harassment in there, which is really important, I think, that we cover, because there is new legislation that will hit, I think it's on the 26th of October, which moves a lot of, it ties up the legislation, makes it tighter, makes sure employers really look at sexual harassment and really take take necessary steps, all reasonable steps to make sure that doesn't happen re their employees, and that will now expand. I mean, Hannah, you touched on this briefly about the proposals do include third parties, which means that you need to look after sexual harassment broader than just your workforce. Do you want to just flesh that out slightly?
Yeah, I think this is a significant proposal because currently there is a preventative duty that comes into force on the 26th of October to take reasonable steps to prevent harassment, but there's no right for the employee to bring a claim in the employment tribunal in relation to third-party harassment. So this is a significant expansion in terms of including third-party harassment in those rights, that enforceable rights in the tribunal, but we don't know watch this space essentially on that one.
So, I mean, even for, I think it's fair to say that, for FSB, where we have staff, we have recruiters, membership advisors who aren't staff, we have volunteers, we have members. So we would need to look at that, for example, as an organisation, and, we will be. So I think we've answered every single question, hopefully in the chat. So thank you very much for all those questions. I'm just about finished. So before we do, Amelia and Hannah, I would like you to give your one overall top tip for small businesses watching as they sit back, consider all these elements for the next year or 2 years for the business to how to deal with this. So Amelia, what's your top tip, top suggestion?
My top suggestion is keep a lookout for everything that FSB is doing, both from a policy perspective and a lobbying perspective, and from the legal perspective from Markel. As I mentioned earlier, we're collecting a numerous amounts of evidence and data that we can inform the government to challenge and present some solutions to some of these issues within the bill. And also just to keep optimistic. I've come across so many of our members who are employers who are doing some great things, providing great employment to many people. Please keep on doing that. Where you think you are not too sure about what's going on, pick up the phone, contact the employment helpline. And if you think you've got some information that would be really useful for us from a lobbying perspective, do get in touch.
Great, thank you. And there's actually one question that's snuck in. We'll be launching an e-learning session on sexual harassment. I think what's wonderful is our webinar today is run by Lindsay and Keziah. So Lindsay and Keziah will be considering that within their webinar program. Thank you very much. I guess neither of you were thinking you were getting some questions today. So let's do Hannah next with your top tip, please, to bring us to an end.
Yeah, my top tip, it will be a note of reassurance to small business employers not to panic. If you are an FSB member, there is a treasure trove in terms of resources, in terms of guidance, template documents that you can use. You've got easy access to the legal advice line. If you're not a member, I'm going to say this naturally, I would encourage you to think about becoming one. So that would be my top tip, take legal advice.
Thank you very much. Yeah, and I suppose I just had keep an eye on wherever you get your information from about us. You got here because you saw us somewhere, but there's the member newsletter each month. There is something called Weekly Brief we produce every Friday on what's happening. That's published on LinkedIn, and it's all beautifully laid out and really easily accessible information. So keep an eye on that, and the legal bulletin that Hannah mentioned from FSB Legal Markel and the Hub. And with that, our time is up. So thank you very much to Hannah. Thank you very much to Amelia. Thank you to everyone who tuned in, and especially those who submitted questions and we got through, I think, them all, and hopefully almost all. For anyone who registered for the event today, you will receive an email with useful links for follow-up, and the video will be available to watch again on demand, which is great for those who couldn't watch live this morning. So if you're an FSB member, I would like to I'd like to add a really special thank you for your membership. We are so grateful that we can exist and be the voice for the community to get positive small business changes to public policy. We can only do that thanks to your subscription. So thank you. If you're not an FSB member yet, the counterpart to that is perhaps today you've got a great feeling, perhaps for the first time, about what we're about and what we're doing and what to support and want to support us. So if you've heard that and you'd love to join, fantastic. If you've heard that and think, oh, I need FSB Legal in my corner, yes, you do. And so to kind of join us, all you need to do is visit our website, fsb.org.uk. You can join instantly online, or you can click the link to for a chat with one of our fantastic membership advisors. It will be great to have you as part of FSB's family. So thank you. We're bang on time, and goodbye.